meeting, I'm going to be updating you on something that's happened in the last few hours. A lot of my attention has been focused in the last few hours on what's occurred, and I'll get to that in a moment. You know, I understand that I'm speaking here at the Republican Party. If the Democrats would have me, I would come speak to them. If the Independents would have me, if a bowling alley committee would come have me at this point, I would come and speak. This is not political.
Right.
This is our community.
Yes.
And I want to tell you how this crusade began, just so that I can at least rebut some of the things that have been said about me. I am not running for the district attorney. I'm not. There are qualified people who are out there that are former prosecutors, lifetime prosecutors, who are going to put their name in the hat at the appropriate time, but I'm not. I was approached by a judge who asked me to have lunch with him, and I did. And I really did not know at that time the problems that were happening inside the DA's office. I'd heard rumblings, but I didn't really know the problems. And after that time, I had to give it some serious thought as to what to do, how to do this. And I'm going to be 42 on Saturday. I am one of those that decided to have a child in my 40s. And one of the cases that the judge told me about was a sexual assault case of a child in Oconee County that struck me. And at that time, I went home to a 3-month-old, and I looked that 3-month-old in the eye. And I thought, if something was to happen to you, and your dad had the ability to do something about it, and you didn't, how do you look her in the eye? And I made a decision at that point to do what needed to be done to bring awareness of what's going on in our community. And that was it was a changing moment for me, because everybody always tells me when you become a parent, you change. And I saw it right there in front of my eyes. And that's why I started it. And I know that there's been a lot of people who have said other reasons why I did this, but it's not. So then I'm gonna break this down, the speech down, into where we are. And so everybody can get a real education. When my wife, when I changed into a suit to come speak today, she said, just remember you're not talking to lawyers, and to make sure that they understand what you're saying. And I'm gonna give my best shot at explaining to y'all what is going on in now 4, in which will probably be 5 actions starting this week. And I'm gonna start with the writ of mandamus, okay? And so the writ of mandamus is something that we are allowed here in the state when a taxpayer citizen believes that a public official is not doing their job, okay? Now, it has been used sparingly through the law. You're not going to find a lot of Georgia Supreme Court cases or Court of Appeals cases dealing with writ of mandamus. What we are doing and what we're proceeding with is making law. And lawyers sometimes say that flippantly, but this is true. We are making law with what has been filed in this. So when you ask a public official to do their job, for instance, if you filed a mandamus because a dog catcher was not catching dogs, and you ask a court, get this dog catcher to go catch dogs, then that's where you would bring that. Or if a county commission was not doing their job with the way that they were supposed to be funding something that they were required to do, you bring it to the court, and that's why we have different branches of government, right? So the DA is not a constitutional officer. Let's start with that. A lot of people think that the district attorney is a constitutional officer like a probate judge or a clerk of court. They're not. They are a statutorily invented office, meaning that when the Gold Dome, when they decided to make DAs, they put in there statutory duties that the DA was supposed to do. So I took that statutory duties with the help of Mr. Miller, who had a very, if you've watched any of the interviews with Mr. Miller, he had a very big connection regarding crime, which was ultimately, it was first indicted by Ken Walden, but Mrs. Gonzalez failed to prosecute it, and that was something that caused him to want to come forward. So we brought it on behalf of Mr. Miller, and all we did was it said, hey, here are the statutory duties you are supposed to be performing as district attorney. Well, how did I find out about those statutory duties? For the course of 2 months, I used the Open Records Act to find out what was going on in Deborah Gonzalez's office. I filed a tremendous amount of open records. And in the beginning, I was getting information. Then ultimately, when that information was used in the lawsuit, the open records stopped. First of all, the Athens Clark County, the county attorney is helping to respond to my open records request. So I was getting the information timely, and I was getting the information that would allow me. And I'm sure that no one has read all 8,000 pages of the writ of mandamus of exhibits. If you had, I would applaud you, and you'd probably, it's a good nighttime read, but you get through all of it. But I have, my office has, and we attached it. And we just wanted everybody to see, just read what's going on and how she is not performing those statutory duties. And I cannot make her go back and do anything that she has already done. Can't change that. I can't do that under this action. All I asked her to do was to do her job and to do the statutory duties that she was required to do. Well, as Houston already pointed out, she went to the PAC. She first went to the AG's office, to Chris Carr's office, to ask her to defend it, and they declined. She then went to the governor and asked the governor for money to defend her, and he declined. She then went to the PAC again. She first started at the PAC when the writ of mandamus came about, and they said no. And then she went back to the PAC, and they gave her $75,000 at the first go-around to defend herself against the writ of mandamus. The maximum billable hour per attorney was $275, and that $75,000 up to $75,000. So they get involved. It was an Atlanta firm. They're famous for representing people like Larry Flint. They've also represented, on the other side, some of the gymnasts that were part of sexual assault crimes. They've done that. They're a big time Atlanta firm, well respected, and they came in, and there was some lawyering back and forth, but ultimately they filed a motion to dismiss my action that said Mr. Miller can't do this, that this cannot be done. Well, all of the judges in our circuit recused, and Judge Emerson out of West Georgia came and heard the case. And some of y'all, I've seen some faces that some of you were there. We briefed it. That means we just argued what the law was back and forth. The judge heard oral arguments, and then he dismissed it. And then he denied the dismissal, and the case moved forward. I have attempted, since this has begun, to take Deborah Gonzalez's deposition. Now, if anybody knows what a deposition is, that's where you sit someone in the room, and there's a court reporter, just like you were in court, that takes down every question and every answer, and so I could just ask what's going on. Just tell me why this, and I can present papers just like I can in court and say, tell me what's going on. Well, when he denied the motion to dismiss, my ability to depose her and to take depositions of other people started. It started that day. So that day, I contacted her counsel and said, when can we schedule her deposition? When can we get going on this? Because I've been waiting a long time, and now it's the time. What did they do? Legally, a maneuver, it's unique. They confessed to the judgment. You may have seen this in the paper. They confessed and said, okay, we'll do our job. Now, some of you in the room may think, that's great, Kevin. She did it. She confessed to the judgment. It wasn't what you thought. She did it so she could get an immediate right to appeal to the Georgia Supreme Court. And she did it in order to try to stop me from being able to depose her and to get into the facts of her office. Now, we believe that it was improper. So we filed a motion in the trial court here in Athens that said, let us keep going with discovery while this appeal is going on because it's not proper. And we are going to wait on that ruling to see what the judge is going to do. But the Georgia Supreme Court has set the briefing, and there will be an oral argument as to this case set for September in front of the Georgia Supreme Court as to whether or not this case was properly denied the dismissal, so we can move ahead with that. The writ of mandamus is important for a multitude of reasons. If you have an opportunity to read it, you can go to the website, lawsuitagainstda.com, you can read it. And what you can see is in those statutory duties that were created by the legislature are just fundamental things, right? Indict crimes that you're supposed to indict. Keep victims informed of their crimes. Make sure your officers are properly subpoenaed so they can show up. Make sure that they're informed about their cases, because he's not just arresting one man. He has a whole caseload. His officers have a whole caseload. They have to properly be prepped in order to do those. Those are some of the things, some basic things that we were asking her to do. So it will be interesting to see where this goes. We will create law. This will create law, no matter what happens. If she flips Judge Emerson and that he should have dismissed it, it will create law. But if they agree with Judge Emerson, then we will keep going and we'll see where this ends at the end of the day. But it's important for this community. So you have that, okay? So a lot of times when I file these things and they get publicized, I get calls, lots of calls. I have been called by a group that found the mandamus action in Atlanta and have asked me to represent them as apartment owners. They own over 3,000 rooms of apartments in Fulton County to bring a mandamus against the magistrate courts there because they're not proceeding ahead with filed dispossessories. This was just a call that I got to represent these groups. But I also get other calls. And in probably one of the most important phone calls I've ever received was a victim's mother here in Athens. And I'm going to tell y'all something. I've never cried in court. Ever. I cried during the Marsy's Law case. Because these are real people.
Yes.
And sometimes when you read articles and you read, oh, she dismissed this, or she did this, or something happened here, you lose sight that these are real people. This was a mother whose 14-year-old daughter was raped by her father. He just didn't rape her, he also raped her sister. And after he raped her, he put marijuana in her food to keep her in a pretty mellow state so she couldn't cry out. And when her mom would go to bed, he'd rape her in the garage. His own daughter. And I'm going to tell you all a story because this story was told in the courtroom. And I think it's very important for y'all to understand this story. So this guy's in jail. He's in prison. Father. And oh, by the way, after he raped her, he beat her to the extent that there are felony charges pending against him on top of the rape and incest and sodomy charges that were against him. And he gets a burner phone in prison. And he begins to contact his daughter and the mother. And at one point apologizes for raping her. Trying to talk them to stop. Don't move ahead with these charges. That was told to our district attorney. And our district attorney did nothing about that. Those phone calls, text messages, any of those. I'll tell you what happened with them in just a moment. So, this mom and this victim are being told through various text messages of what we call victim's advocate. Victim's advocates work for the DA. They are supposed to advocate for the victim and keep them informed of what's going on in the case. They're being told here and there about these proceedings and these court proceedings that are happening. And the Friday before the trial, the victim's mother says, hey, this case is going to trial on Monday. You need to be here Tuesday. Her response, what? What's going on with this case? And at that point, he said, can we meet at a park on Sunday and discuss prepping for your case? Can we meet in a park? They live in Gwinnett, between here and Gwinnett. An interesting place to prep a survivor of rape. He met with her for about an hour that Sunday. On Monday, Mr. Robert Wilson, who was the chief assistant for Deborah Gonzalez, steps up and says, I need a continuance of this case. The judge asks why. And he says, I'm not prepared. I haven't subpoenaed the witnesses. I have said, my bad, Judge, it's my bad. And the judge says, this is a very serious case. This is a very, very serious case. And I'm going to give you today, after we pick this jury, you're going to go get these people subpoenaed. They knew who they were. They were ACC police officers. They were the forensic analysts who did the interview with this young girl. Now, she had quit her job, but she was the daughter of a very known car dealer owner right up in Winder. Knew where she was. She had testified 2 weeks before for the DAs. In other cases, she had appeared on subpoenas. She'd been in cases. She took her job very seriously. Although she left interviewing victims of rape, she kept everyone informed of what was going on. And he said, listen, you need to get these people under subpoena and you need to get them here. Well, this is where the story kind of takes a turn. As you well know, the district attorney's office is understaffed. You've probably heard it once, you've heard it many times. And she is severely understaffed for a multitude of reasons. It is not because of salary. It's not. It is not. There's a study that's been done related to her office and where they went. A lot of people have either left for the same amount of money or for lesser money. So it's not that. So the week after this murder trial, this rape trial was supposed to happen, there was a murder trial that Ms. Gonzalez was handling personally, okay? And she asked Robert Wilson, that was handling this rape trial, to jump on with her to be a part of this murder trial. And when he started asking for the continuances, we didn't know why, but we know why now, because of some of the documents that we have received, some of which I still haven't gotten, but a lot of them I know why. On the Thursday of that rape trial was a major motions hearing as it relates to that murder trial the following week, and Robert Wilson was going to have to cover for it because this understaffed, short-staffed office, Ms. Gonzalez had made a trip that she had planned out to Selma, Alabama. A lot has been made of my request about Selma, Alabama, and what she was doing there. She's told the press that she was there to learn about civil rights and her ability to serve as district attorney and those sort. But she was a dereliction of her duties because she was giving up a major motion hearing related to a major murder trial the following week, which Robert Wilson would then have to cover. So he didn't have the time or the attention to this rape case. So the judge says, pick the jury, and he knows he's got Thursday coming, and he's just pushing for a continuance. Judge, I'm begging for a continuance. I need a continuance. And what is the defense attorney doing? What does a good defense attorney hear when a prosecutor's begging for a continuance and doesn't have his people subpoenaed and doesn't have this case ready? What would you do as a criminal defense attorney? Judge, we're ready. Let's go to trial. Let's push it. Let's go. This is all on the record. You can read it. So the judge says, pick the jury and get your investigators out there. They have investigators to go put subpoena in the hands. You know what it takes to subpoena people, folks? You draw up a subpoena, an attorney can sign it, and you walk right up to somebody and you do this. You hit them with a piece of paper. They've served. That's it. That's it. I want to tell y'all something. At the Marsy's Law hearing, the judge gave me a few days before the hearing. Every person that needed to be subpoenaed for that rape case was subpoenaed by my office and showed up and was there and was willing to testify to the truth. So the jury's picked. That's the Monday. He's given the instructions to go get the people. And on Tuesday, that's when the mom and now the 16-year-old victim showed up at court for the first time. Now, were they allowed in the courtroom? No. No. Mr. Wilson stopped him right before the courtroom and said, I need you to come into this conference room over here. And walked him in there. Sat him down. It says, you need to dismiss this case. They asked why. He says, we don't have a strong case here. We don't have a strong case. You need to dismiss it. You know what's interesting about that? When I subpoenaed her the records of her office about their take on this case, internally their notes said this was a strong case. This was a good interview. But no one ever looked at the messages that he sent from prison where he apologized for raping her. They never looked at them. They had an admission of the defendant, but they're in the room telling the mom and the 16-year-old, dismiss this case. Not because we haven't done our job, not because we haven't subpoenaed the people, not because I'm ill prepared, not because my boss is in Selma, Alabama, and I got to cover a hearing on Thursday. No. Because this is a bad case. He leaves them in the conference room and he walks into the courtroom. I know the whole story because I have the transcripts, and I showed them to the mom and the 16-year-old who had never seen this before. Judge, I need a continuance. I wasn't able to get the witnesses like you told me to do. Well, what do you mean you weren't? She wouldn't accept the subpoena. What do you mean she wouldn't accept the subpoena? You've been subpoenaed. What do you mean? She just didn't feel like she was given a proper enough time to prepare. Well, I contacted that victim. I contacted that witness who was willing to come testify at the Marsy's Hall. And let me tell you what they really did. On that Monday, after the judge told them to go out and subpoena the witnesses, one of the investigators went to the dealership in Winder and asked to see the individual. She thought that it was her customer from Eatonton. He walks in and says, I'm with the district attorney's office. I have a subpoena for you. I'm subpoenaing you for a hearing. She goes, what about? What case? What are we talking about? I'm not sure. She had been text messaging people to find out what was going on with Robert Wilson with no response. So instead of serving her the subpoena so that she could go to the judge, he could go to the judge and say, hey, we subpoenaed him. He didn't do this. He walked out. He walked out. He never gave the subpoena to her. And so Robert Wilson says, I need a continuance because I couldn't get this witness here. The judge says, no, we're moving ahead. Can I have a break, Your Honor? Yeah. He walks back out. He goes into the conference room with the mom and the 16-year-old and doesn't tell them that the reason that they need to dismiss the case is because he has a subpoena or the judge won't grant a continuance. He says, this is a bad case. We need to dismiss this case. This is a real bad case. We can't prove it. Okay? I said, we don't understand. We want to move ahead. We want to move ahead. My little girl's been raped. We want to move ahead. So he goes back into the courtroom again and begs the court for another continuance. And the court says, you know what? Let me be the bad guy. Let me be the bad guy. The witnesses you can't get here to prosecute this case, let me issue a material witness warrant. Now let me tell you what that is. If I know Gordon to come to court and Gordon needs to testify and Gordon won't show up and he's material to my case and he won't do it, the judge has a right to say, Sheriff, go get him. Lock him up, put him in the back of the car and bring him here. The judge told him that he would do this. Judge need a break. He walks back outside that courtroom and once again goes into the conference and asks them to dismiss it because it's a bad case. Now this is the part where I cried in court. Mom said, can I talk to my daughter alone? I said, sure. The mom took the 16-year-old and said, honey, they're saying this is a bad case. And we're going to lose. Can you confront your dad knowing you're going to lose? They're going to think you're a liar, that you weren't raped. They're going to go after you, sweetheart. You got the courage to do that? Little 16-year-old girl looked her mom in the eye and said, Mom, I didn't have the courage to do this. I didn't have the courage to do this. But I do now. I can do this, Mom. Even if we lose, it's okay, Mom. Let's go. He did it to my sister. He did it to me. We can do this. They walk out of that conference room. And they tell Robert Wilson, it's okay if you lose. We're okay. Just give us our day in court. Let us confront him. With this knowledge, Mr. Wilson walks back into the court, says, Judge, I need a bench conference. That's where you go up and speak to the judge so not everybody in the room can hear you. It says, we're dismissing this case, Judge. He walked back out of that courtroom. He walked into that conference room and he said, I'm sorry, the case was dismissed. There was nothing I could do. And she said, why? What are you talking about? And he walked out of the room, didn't respond, and never came back. She looked at the victim's advocate and said, I need to speak to Deborah Gonzalez. She said she's busy. She'll get back with you after lunch. They leave. They don't hear anything. So they called and said, to speak to Miss Gonzalez, you're going to have an appointment. So they set up an appointment on May 2nd. That afternoon. Miss Gonzalez called. The victim's mom asked, we'd like to know why our case was dismissed. And Miss Gonzalez said, I don't know anything about your case. I have to get back to you. I'll call you back. And never called back. By law, we have to call what happened to that 16-year-old girl as a victim, but she's a survivor. Not only did she have to survive the rape of her father, but she had to survive what Deborah Gonzalez's office did to her. So we filed a Marsy's Law case. Marsy's Law started in California. It was adopted in our state constitution. To my knowledge, there had not been a Marsy's Law case filed in Georgia, ever. We get there. There's some people in this room that were there to support this family. I see them. The little girl was there, and her mama was there. And while Ms. Gonzalez tells you in editorials, Coney Enterprise, how important it is to speak for victims, and how she tells everybody in the public how important it is for victims to be able to have their voice and speak. For 2 hours, she fought me. 2 hours, she fought me so that mom and little girl couldn't speak in court. She lost. Let me tell you something that happened after that. She walked out of that courtroom and she never came back. Robert Wilson stood in there And here's a little known fact, which a lot of y'all don't know, but in front of 2 ACC PD investigators who were prepared to testify to this, that when they were arguing with each other, and let me tell you who they were, Robert Wilson, the chief assistant, and Deborah Gonzalez were arguing outside the courtroom as to whether or not they should admit to a Marsy's law violation. Robert finally said, if you don't admit, he's going to get into everything we did. And my investigators who I had subpoenaed that day were prepared to testify to that. So he walks back in and he admitted to it. And this mother took the stand and talked about how they're in therapy. They deal with this every day. How her little girl became so depressed that when she got home every day, she would just go in the bed and just lay there. And after the dismissal, what it did to her. Y'all forget Republican, Democrat, whatever you want to call it.
That's right.
This is human. These are children. Our community needs to know about this. When the judge ruled against her, Deborah Gonzalez said in the hearing that she's going to file an emergency appeal. Mr. Bushnell would know there is no such thing as an emergency appeal. But I had subpoenaed records for her to bring into court to explain how they got to the point that they did. Selma, Alabama, a good case during tracker, but somehow you're telling the victim that it's not a good case. Bring those documents into court. So they filed what they called a motion to quash my subpoena. Well, the judge denied it. And as soon as he denied it, I went, well, give me my documents, let me see. And what does Ms. Gonzalez said? We don't have them. I haven't got them. I haven't prepared. So what did I do? I moved for contempt of court against Ms. Gonzalez immediately. The judge gave her 15 days to respond. She responded this past 2 Saturdays ago. Here's the interesting thing. I mirrored the subpoena after an open records request that I sent to her. Mirrored it. Exact same language. In response to the open records request, she told me there were over 1,300 documents in response to it. In response to the subpoena, she gave me 45. Where are the rest? What did they say? So in that action, we filed a motion for contempt, and that is pending. We have filed a motion to file all the documents under seal. We want the judge to see everything that we saw. And we've asked her to hold her in contempt until she complies with the subpoena. That hearing will be coming. And I want to make sure I do time right by Gordon, but that's the Marsy's Law case, okay? Now, for what the press has picked up the most recently, the open records request, okay? This one's a little bit more complicated, a little bit more detailed, but let me tell you how it happened. Eventually, as I told you in the open records request, that the county attorney's office stopped responding to her and turned it over to Ms. Gonzalez. So several months ago, I sent her an open records request. It was detailed and there was a lot, and it was asking for a good amount of information, but nothing insurmountable. Ms. Gonzalez responded herself. And in that, she said that it would take 169 hours for her to get it because she's the only one that could do it and she's so short-staffed. And that based on her hourly rate she would charge me, it would cost $4,700 and change. Thought that was a little unusual. So I started doing something a little bit different. I said, if you're so understaffed and you don't have the time for open records requests, we'll send you one open record in the morning so you can do what you've got to do in court and respond to it, and we'll send you one open records request in the afternoon so you can look at it and respond to it. We did that for 45 days. Very targeted information that the public would want to know. We didn't get a lot of responses. Not a lot. Under the Open Records Act, a public official is required to respond within 3 days with the documents. We're well past that on these documents. Then something happened. Something happened in Mrs. Gonzalez's office. She had a chief assistant named June, and Ms. Gonzalez asked June to cover one of her hearings for her 1 week on short notice. The reason? She had to go meet with her attorneys to defend herself against the mandamus action. So when June looked into the file, she recognized the officers hadn't been subpoenaed. There was nobody there to testify at this hearing, so she let the court know that they were not prepared to move ahead. And guess what? That would have been subject to the open records request that I had pending. Ms. Gonzalez finds out about this. She gets extremely upset about it, and she calls June in to fire her. June's smart enough and figures it out and says, "You're not going to fire me. I quit." And she quit. And then she contacted me and said, "What do you want to know?" Because I'm ready to tell. Now, for several months, I've been sitting on something because I've been waiting to see how this plays out with Ms. Gonzalez to whether or not she was going to comply with the open records request. But June filled out an affidavit for me. And in that affidavit, she stated that Ms. Gonzalez contacted her after June had sent her some text messages and said, "Hey, I need you to delete those text messages. I'm getting a lot of open records requests and I wouldn't want that to wind up in the newspaper. That's a felony under the Open Records Act. At least that's my opinion of it, and that's what we've pled. You can't delete things that the public has a right to see under the open records. And even if you thought that the information would not have been subject to the open records, that's not your right to do that. When you take the job as a public official and you take state funding and you take local funding, you subject yourselves to the laws of the state. And one of which is a public official is that anything you do inside that office, we can come see as part of the open records. And she denied the citizens and Mr. Miller of that ability to get that documents, those texts. Amazingly, 11 Alive had some open records requests out there by themselves that were looking for these documents. And amazingly, Ms. Gonzalez responded to the 11 Alive open records request. And amazingly, the date in which she deleted those text messages, they do not appear. I know it. 11 Alive knows it. June knows it. And now Deborah knows it. Because that affidavit is filed in the lawsuit that was filed in Athens, Clark County last week. And in that lawsuit, we've asked for several things. We've asked for her to comply with the Open Records Act. Comply with it. Respond to the requests that I put out. They asked for me to pay for them, so I did. I paid for all my open records requests, just like any citizen is required to do. So what do? An absolute defense to the Open Records Act is, in a lawsuit, is to give you the very open records you've requested before I have to get in front of a judge. Well, guess what's happened in the last week, everybody? I'm starting to get inundated with responses to open records requests. She's starting to give them to me. And I know why she didn't want to give them to me. Because I'm seeing the reality of the situation that's in that office, which will be shared. There's a new website that's going to be launched that will be shared, and you will see everything that I see. And the public will see everything that I see and Mr. Miller sees, that you have a right to see. And you will do it. But also in that open records request, in that lawsuit, I've asked the judge to issue. You cannot seek a warrant against a public official, just like I could go, if Gordon was to beat me up, I can go to the magistrate court and say, give me a warrant against him once arrested. You can't do that against a public official. You have to take the evidence to the judge, and the judge issues a citation which directs the sheriff to go and arrest the public official. We've asked her to do that based on June's affidavit, and June is prepared to testify in court as to what she did. So we'll see how that shakes out. That's where that is right now. She has 30 days to answer. And I'm attempting to take her, you're not allowed to take depositions until after they file an answer. And I've noticed her deposition for the 31st day. So we'll see if I get to take it. Now I need to tell y'all, and Gordon, I promise this is it. And I don't want to, I know time is valuable, but I just want everybody to know what's going on. And this is something that's happened over the course of this weekend, and I think it's very important for everybody in this room to know this because it's very important about the citizens that were happening. I'm going to say a name to y'all, and I want you to remember it. His name is Nigel Brown. Nigel Brown is an individual that lives in Athens, Clark County, who, in my opinion, and as the evidence seems to show, is a serial rapist. He rapes homeless women, women that don't have a voice. They have a voice, I should say. It's just not heard a lot, especially in our criminal justice system. Nigel Brown, in June of last year, went to the Walmart on the east side of Athens, and there was a homeless woman there with her phone. She explained her situation, how she had a friend that was going to help her with a bus ticket to get her back to Brunswick where her family was, but that he had bailed on her. And he said, "That's okay, I can help you. Do you have any money?" And she has some money because she lost her son, and she has some money that comes to her monthly. He said, "Yeah." He said, "Well, come with me. I'll help you get a rental car so you can get home." Puts her on a bus with him, goes some stops down the road, and takes her to the mother's townhouse. Gets her in the townhouse, closes the door and puts a cinder block in it, and tells her how he beats women for fun. He then takes a knife and stabs it through her cell phone. This is graphic, so I'm sorry, but I think it's important to know. He then holds a knife to her throat, makes her perform oral sex, and then takes her into a room and rapes her. She is able to escape and run away. She had all of her belongings with her, 2 duffel bags. He took one of her, she was able to take one, and raped and beaten. She was dragging her stuff down the sidewalk when a gentleman saw her in struggle and said, "Can I help you, ma'am?" And she noticed that he had a pizza emblem on a store over there next to the Walmart. And so she trusted him to get in the car, and when she got in the car, she finally told him what was happening. And he said, "You've got to call the police. You've got to." So he helped her with his phone call. The police in Athens, Clark County shows up. And they could not have been more professional and reactive. So she tells him where he took her. And the police go there and question him. Says, "I don't know what she's talking about. I haven't had a woman here, nothing." So they go get a search warrant. When they go into the room, they find her stuff, but not just her stuff, but multiple homeless women's stuff, of which on a previous homeless victim, a rape kit has been performed, but that victim did not proceed ahead with the rape. But this victim, survivor, was prepared to move forward with this case. So, Athens, Clark County arrests him. Now let me tell you the rest of the story. I criticize Ms. Gonzalez a lot in the lawsuits that I file, that she doesn't indict people and doesn't always accuse people timely, but in this scenario, they arrest Mr. Nigel Brown and they indict this man in August. It was too soon. They also went and got a search warrant for his DNA, and they sent this DNA off, which takes months to get back. Months. So they indict him in August, and he has a public defender. He's arraigned in February, and the public defender files what we call a speedy trial demand. Let me tell you what that means. That means that the court must try this man within 2 terms of court. And the terms of court are set by Mr. Gaines and the legislature as to what that term is going to be. Well, when that landed in February, that means that we had till July 10th, this coming July 10th, to try this man. So let me tell you what happened. May 2nd, he used to show up to court. And by the way, I've contacted and spoke to some of the ACCPD about this. They had no idea. All the people that worked this case to bring this serial rapist in didn't have any idea that this was going on. She brings him in and she says he's charged with false imprisonment, rape, aggravated assault. Brings him in and she says, we can't find the victim. All of our outreach efforts have failed. We must dismiss this case. So someone contacts me about this and tells me about this case. Last week. Ordinary citizens found the victim in this case in 24 hours. I just met with her before I came over here on this hearing, in this meeting. Just met with her. She just got back in Athens. Let me tell you how important this is. Let me tell you, you want updated new information as of right now, where you're about to get it. If Ms. Gonzalez does not vacate the dismissal this week, she can, and get it on Judge Haggard's trial calendar for June 26th. This serial rapist and the charges against him, that what will happen is jeopardy attaches, means that he walks free forever. He is currently out in this community because she dismissed it. This victim has hired my office to assert her Marsy's Law's victims' rights. Houston's right. On Saturday, the PAC gave $400,000 to Ms. Gonzalez. One of the things that they say, by the way, is that this is costing Athens, Clark County taxpayers money to defend themselves against me. No, PAC made that decision for y'all. PAC made the decision to use taxpayers' funds to defend her. She's an attorney. She could have defended herself, but PAC decided to do that. So once she hired me, I wrote an email to Ms. Gonzalez this afternoon. The time is ticking for this week for her to do something to take this serial rapist off of our streets. I want to read you that email because I think it's important for everybody in this room to hear what I wrote her and what I am requesting of her. Ms. Gonzalez, please be advised that my firm and Lane Fitzpatrick, by the way, is a retired attorney in this town who, if I'm a bulldog, he's a bulldog on rabies. But he believes in the victim's rights. And he believes that something has to be done. Have been retained by the victim to represent her in the Nigel Brown case, SU 22CR 0739H. Lane and I are doing an entry appearance in this case to make sure that all our client's victims' rights are being complied with in this case. Brown is charged with rape, false imprisonment, aggravated sodomy, and criminal trespass. We have also learned that this is not the first time that Mr. Brown has been accused of raping women in our community and potentially is a serial rapist. Attached to this email is the dismissal by you, and this is not any of Mrs. Gonzalez's assistant district attorneys. She herself signed this dismissal. Signed by you on May 2nd, 2023, wherein you stated that the victim cannot be located and has not communicated or responded to various outreach efforts. Without the victim, The state cannot prove its case without a reasonable doubt. The victim, which everybody knew was homeless, was in a homeless shelter in Brunswick and was communicating with a group called Safe Harbor, which the victim's advocate of the DA's office told her to keep in touch with so that they could locate her. Safe Harbor knew where she was. They knew her exact location. She was a bicycle ride to a park in a tent with her boyfriend. The victim wants to move ahead with the case and is willing to do whatever it takes to prosecute Brown. She is on her way to Athens and will be available for any preparation you may need from her. A good citizen paid for a private car for her to be brought up to Athens today. As you know, she was homeless at the time of the crime and continues to be so. We would request that the DA's office provide her with a hotel room as we work through this case. A local citizen has provided her a hotel room for the week. Something that the district attorney's office should be doing with their fund. Now for the case. On June 6, 2022, ACCPD was contacted by my client regarding the rape by Brown. Your office chose to indict him less than 30 days after the arrest and before the DNA results had been returned to your office. By doing so, your office subjected the case to a speedy trial demand. That demand was filed in February of 2023 and is attached to this email. This means that based on the statutory term of court, OCGA 1563, Houston knows what that means. It's just our laws. It's what we call our laws, OCGA. The case must be tried by July 10th, 2023. Judge Haggard has a criminal trial calendar scheduled for June 26, 2023. Thus, the case can be tried within the 2 terms of court based on the speedy trial demand if you request Judge Haggard to add it to the calendar and he grants such request. Here's what we ask. We request that you immediately file a motion to set aside the dismissal and ask the court to place it on the 6/26 calendar. We further request that your office issue subpoenas for the case to have all proper witnesses at the trial, including ACCPD officers who have Axicon videos that I have watched. And I'm sorry to be passionate, but I've watched what these officers did. And his own mother said in the camera, I've told him to stop doing this to strays. This is in our community. We also request that a similar motion be filed with all other victims notified and subpoenaed, meaning by which that the people that he's done this before, get them in court and let the jury hear it. Yes. This matter is of high importance to my client. She's a survivor of a serial rapist, and she's prepared to do whatever it takes to stop the defendant. I understand that you dismissed the case prior to your office receiving the DNA results. I want to say that again to everybody in this room. I understand that you dismissed the case prior to your office receiving the results. She dismissed the case on May 2nd, 2023. The DNA results came in 5 days later. Now let me tell you what those DNA results say. I have attached the DNA results. I have them. I personally have the DNA results. You know how I got them? Through an open records request to the ACCPD, who responded within 3 days. Just like every other governmental official in Athens, Clark County, and Oconee County has done with all of my other requests. The clerk's office responds to them in time. The sheriff's office, the ACCPD, the clerk's office in Oconee, the county administrators, everybody seems to respond to me because it's an open records request and they're taken extremely serious. So I got their entire file. I got to see what the ACCPD did in hours of man hours to bring this guy down. I attached the DNA results that shows that the defendant's DNA is essentially the exact match of the DNA of the individual who raped my client. They is statistically the highest rated DNA match you could have on an individual. We believe this to be a very strong case from a prosecution standpoint. Please make all efforts to meet the victim's request above. And then I put this in all bold. I want to tell everybody in the room something. These lawsuits Mr. Miller has brought, that I've brought, it is not about me. It's not about Mr. Miller. It's not about our egos. It's not about whether or not he voted for her. He did. He's a Democrat, believe it or not. It's not the matter if I'm a Republican, Democrat, Independent. It doesn't matter. This is about victims and the safety of our community. Put this in all bold. Regardless of the litigation that we have going on right now, my client is begging, underline. My client is begging you to stand up for her as a victim of a serious crime. And she's asking you to be her voice against a predator who is attacking the most vulnerable women of our community. As you know, if the actions requested above are not done by your office, this defendant will get away with what he has done to this survivor because jeopardy will attach to these charges. We feel strongly that this will embolden the defendant to rape once again. And he will, in my opinion. And I believe our good ACCPD knows. Houston's right. The Pendergraft case, if you go on 11 Alive and look at it and Rebecca Lindstrom's work, that victim committed suicide. She felt no one was listening. The prosecutor down in Troup County has contacted me individually, and he was told me, please give me the day that I can step as a witness in front of the mandamus action in front of a judge, and I will tell them that Deborah Gonzalez lied to the court, that there was never a deal worked out between our two offices. I never spoke to her office to work out a deal in the Pendergraft case. Pendergraft is one of the worst individuals that has ever made himself through the justice system of Athens, Clark County, and Troup County, and we had the opportunity up here to put him away for a lifetime and failed at it. Forget the fact that you think you can do the job. I ask, as a woman, you are letting these men off who are violently hurting women, raping children. Where is that? Where is that human side of you? Gordon, when you asked me to come speak here today, quite frankly, I knew generally what I wanted to talk to you all about, but I could sit here and probably talk to you for more than 3 more hours about everything that I know. Unfortunately, or should I say fortunately, I've entered into the mind of Deborah Gonzalez through all the different things that when I started this process, I did not know. I know how she feels about people. I know what she says to the public, and I know what she does inside the courtroom. And quite frankly, as my wife says, if you knew everything I knew, it'd be hard to put your head on the pillow at night. And for that reason, I don't know how Ms. Gonzalez does it. I need to ask her something. And I normally would never do this. Never, ever do this. I am doing this pro bono, and I shall continue to do it. And my firm and my partners, we are all ready to do this. And whatever it takes, I don't care. I don't care. At this point, it's about saving victims and people. But I do need help with one thing. This victim of Nigel Brown is in a hotel here in our community. Ethically, I cannot give her money. I can't. And I'm sorry to say I can't. I cannot as her attorney. They got in my office, and I had donut holes, and they hadn't eaten. And they asked if I had anything to eat, and I gave them donut holes and Coke Zero. Just texted me. I told them to text me because their phone only works with Wi-Fi, and they're in the hotel room, and I'm going to go pick them up, and I'm going to go to Walmart with them, and we're going to get just some basic necessities that a person has, and we're going to get some food for them. If any of y'all would like to contribute to them as ordinary citizens, you can. I can't. I would open up my bank account and write them a check today if I could. But if you can help them for this week, and I got news. I don't know, Gordon. I see that we're being recorded by this. I don't know where this is going to go. I don't know if people are going to see it. But I have news for y'all. This story I just told you, Rebecca Lindstrom of 11 Alive is going to be at my office at 9:30 in the morning, and she's going to interview this brave woman, and she has agreed to be interviewed on camera with her and tell her story. And let me tell you a little bit more about it. Rebecca's dived into it, and she's gotten the open records request, and she has an interview that they're ready to put on tomorrow with J. Tom Morgan, who was the former prosecutor up in Atlanta, who prosecuted the sheriff who shot the sheriff's candidate in his driveway. That was J. Tom. And J. Tom made a history of prosecuting sex crimes, and he's going to be talking at 11 Live tomorrow, and this is going to air tomorrow about what's happening with this Nigel Brown and this victim, and that's happening tomorrow. And she bravely, when she reached out to me today, when she called me, she made a leap of faith. She didn't know me. Told her I'm an ordinary citizen and agreed to pay for her to come up here. She and her boyfriend got in the car and drove up from Brunswick, Georgia. I told her once she got here I'd have something worked out. An ordinary citizen paid for a hotel room. And I told her I was coming to speak to a bunch of people today that I believe that after the end of this speech will know how important this is. So if you can, and if you're willing to help as ordinary citizens for this week as they just try to basically survive with food, and her boyfriend came with her. And you know what her boyfriend said to me? I'm ready to work. I don't want to be homeless anymore. I cooked at an Applebee's for 16 years. You got anybody I can work for? And I do. And I told him he's a former Marine, so get ready for some structure. He goes, I think I need that. And you know what she said? I need a better life. Her daughter died of a fentanyl overdose on New Year's Eve after she had lost her child to a house fire, tent fire, from a hot plate. And they've been struggling. So if you have it in you to help out an ordinary person that's just down on their luck and trying to do it, I'd ask you to do that. Gordon, I appreciate the opportunity to speak to y'all. I think it's important that what I'm talking about with you, please don't walk out that door and not tell people. Please. I need every one of you to commit to telling 10 of your neighbors. Reagan had a saying when he ran against Carter, right? A recession is when your neighbor loses his job. A depression is when you lose your job. And a recovery is when Carter loses his. Let me just tell you one I'm coming up with. Crime is up when your neighbor gets robbed. Crime happens when you get robbed. And crime stops when Gonzalez is removed from office.